Hey everyone, welcome back to The Socially Distant Lawyer. I'm Mitch Hayes.
And I'm Greg Vinogradsky.
And on today's episode, we have a treat for you. Everyone needs a Halloween episode, and The Socially Distant Lawyer is no exception. So Greg and I are dressed in our plaids today, and we're going to talk about agro-tourism on the East Coast. The East Coast is full of farms. We represent a number of them, and agro-tourism is a big industry. We want to talk to you today about how it's affected when people come onto the farms and what the law says in terms of picking and recreational activities.
That's right. So many farms on the East Coast have some kind of immunity that the state provides for them. And most of this immunity for torts is centered around the foreseeability aspect, right? The foreseeable harm that somebody might experience when they come onto a piece of undeveloped or unkempt property. And these typically would fall under two categories: picking of pumpkins or apples, or some kind of a recreational or sporting activity. So when people come onto a farm, they come to pick pumpkins or apples or anything else that the farm might be producing at that time. And the question for tort immunity revolving that type of industry is whether the person that came onto the property that fell or was hurt fell on a natural risk or a hazard that was inherent in that land. Or whether it might have been a man-made type of hazard that was created there. And really that's kind of the turn on whether a tort immunity would apply. So I've had a case a few years back where somebody was on a farm and ended up hurting themselves. The facts briefly were they were leaving a porta potty, stepped out of the porta potty, turned their ankle on a ditch. And our argument was that tort immunity applied because that ditch was a natural risk or a hazard that was inherent in that land.
So in that case, while we were defending the farm and the landowner, the plaintiffs obviously had arguments against our immunity. And what they were saying is that the porta potty should not have been located in that area. It was not a naturally occurring condition of the farm. It was a man-made risk by putting that porta potty in location, which was trafficking a lot of people. So for people going to farms this time of year and participating in the agro-tourism industry and helping to sustain farms, that's an area that the farms need to look into, is that people coming onto the land, not knowing specifically what the land condition is, and there have to be man-made conditions that may prevent us from having tort immunity. And it all goes back to the foreseeability of harm argument.
So the other category that this falls into, outside of picking pumpkins or apples, would be whether somebody is there on the land for a recreational or sporting purpose. And this kind of comes down to what counts as recreational or sporting for the tort immunity to apply. Some things are obvious. If you're there for ice skating, if you're there riding a dirt bike, that clearly is a sporting activity. But what about if you're there for a corn maze? Or what about if you're there for a hayride or some kind of a haunted house? Is that considered a recreational activity where a tort immunity would apply? And the next kind of caveat or application of this immunity is whether a fee has been charged for that person to come onto that property. In almost every state, once you charge a fee, you no longer have this immunity applied to you, which makes sense.
So the fee issue is the biggest issue that we have here in determining whether or not immunity applies to the landowner, even if the activity was a recreational activity. One of the questions that is posed a lot is if a farm is open to a number of different activities. So a farm has a you pick it section, but it also has a haunted house or maybe a corn maze, and the admission or the fee charge is only for a select activity. So how does liability and immunity play in that specific activity? And that's a question that's always been before the courts. It generally is going to depend on what the fee was actually paid for. So was it paid to do everything, or was it paid to do a particularized activity? That's really the question that we have to get into as these cases come to us and the cases develop.
Thanks for tuning in on our discussion on agro-tourism and tort immunities that might apply in your state.
Please follow us on our social media channels, like, comment, subscribe, and happy Halloween.